Welcome you all to the lecture series on corporate law. The present lecture, I will be discussing on the basic concepts of buyback of the shares and Section 68 of the Companies Act, where the Section 68 of Companies Act deals with regard to the power of the company to purchase its own securities. If you see the text of the Section 68 of the Companies Act, it says the company's power to purchase its own securities. Now, let us try to understand what it all means, how the buyback as well as to the company's powers to purchase of its shares will change the dimensions of the corporate law. Let us take a small hypothetical problems. If there is an ex-limited company and it has 500 shares, each one is having 1. So therefore, totally we are having 500 members, right? So if there is an ex-limited company in which you have the 500 shares held by 500 members, each one is having the 1. This is one small example which I am taking and try to explain to you the simple terminology on the buyback of the shares. If the ex-limited company is willing to purchase, right, is willing to purchase 100 shares back, right, it wants to purchase 100 shares. So once the ex-limited is purchasing 100 shares, the total number of shares will be later 500 minus 100, it will be 400 shares. So to understand a simple logic, if ex-limited company is having the 500 shares held by 500 members, it is planning to take it back 100 shares and from the 100 shareholders, then the 100 shareholders may surrender their shares. Then total number of the shares will be, after the buyback, it will be 400. Automatically 100 shares will go out. It is a simple hypothetical problem. The another question comes here is that once the company completes the buyback, the company has to pay the money to the shareholders, right? For 100 people, it has to pay some money. Now the question will come from where this money will come, right? Ex-limited company can take this money from the share premium account as well as to the free reserves of the company's accounts. In the simple understanding of this particular concept, here company is the buyer, right? Company is the buyer, shareholder is the seller. So the transaction between seller as well as to the buyer. So company is purchasing, right? Company is purchasing and the shareholder is selling. So now when the shareholder is selling and the company is purchasing, company is supposed to pay the money from the available accounts or from available balance sheet records or the profit and loss account. So in that process, it has brought with the concept that the company can go for the buyback of securities as provided under the Section 68 of the Companies Act. Section 68 of the Companies Act is both procedural law as well as substantial law. We have to read Section 68 of Companies Act followed by SEBI Buyback Regulations 2018. So if anybody wants to understand the subject of buyback, if anybody wants to be mastery of the subject, the person has to read the rules which are available for the SEBI buyback as well as under section 68 of the Companies Act. Here I try to explain a small example where the shareholders will sell their shares to the company. Company is going to purchase. When company is going to purchase, some of the legal issues will come. The legal issues are why company is purchasing, as well as at what price. At what price company is paying money to the shareholders, from whom it is purchasing. These questions will arise in Companies Act, right? What is the reason for buyback? At what price it is purchasing? From whom it is purchasing? These legal questions as well as the questions relating to the management would arise in order to understand the buyback process. Now let us see what the Companies Act talks about reasons for the buyback. According to the concept note or the report which is available for the introduction of the buyback in Companies Act, there are some of the reasons are provided. This is the reasons available under the background concept note, where the buyback of the shares were introduced in the Companies Act from 1998 onwards. Because prior to the 1998, buyback concept was not there in the Indian corporate law. So it was introduced the later part of the capital markets. So when the buyback was introduced in the capital markets, the drafters of the regulations provided the certain reasons and also the requirements for the buyback. So the one of the requirement is that to return the surplus cash to the shareholders. So what is the surplus class? Surplus cash is already there in the reserves and surplus. If you see the balance sheet of the companies, under the balance sheet of companies, you find the reserves and surplus. Reserves and surplus is not useful for the day-to-day management, is not useful for day-to-day expenditures. So number one, the reserves and surplus can be taken out and will be paid to the shareholders. Number two, to increase the underlying share values. Number three, to support the share price during the periods of temporary weakness. If the capital markets, if the share price is very less, if the company is going for a buyback, automatically the share price or value of the particular share will be increased, because in the case of the buyback, the understanding is that the companies are having very good financial status. So one of the reasons to support share price during the periods of temporary weakness. Point number three, to achieve and maintain target capital of the structures. And point number five, to prevent or inhibit unwelcoming takeovers. This also we call it as to prevent from the hostile takeovers. So to prevent the hostile takeovers in capital markets, there is the one of the mechanism where the companies can go for the buyback of the securities. So the reasons for the buyback are provided in the concept note, whereas in the Companies Act, the reasons are very silent. Now let us see some of the provisions or the phrases which are provided in the Companies Act. Now we are moving on to the section 68 of the Companies Act, where it says power of the company to purchase its own securities. I will repeat again, power of the company to purchase its securities means section 2 clause H of SCR Act, that is Securities Contract Act 1956, defines the securities. So therefore, don't confine only to the shares. Under the previous legislations, that is the 1956 legislations, we use the term of shares, whereas under the 2013 Act, we use the language of securities. Securities includes shares, stocks, debentures, venture capitals, mutual funds, and so on. So various financial products, various financial instruments are part and parcel of the securities. Now let us see about the provisions of Section 68. I will repeat again. Section 68 of the Companies Act, which has more than 12 subclauses, is both substantial clause as well as procedural clause. Substantial clause basically talks about the rights of the individuals, whereas when you talk about the procedural clause, it also provides the procedures and mechanisms how you can go for the buyback. And see the language of the Section 68. Notwithstanding anything contained in this Act, but subject to the provisions of subsection 2, a company may purchase its own shares or other specified securities. So it has two. One is about other specified securities, and also it can go about the shares out of the free reserves as well as out of the securities premium account. So from two accounts, it can collect the money and it can also pay back to the shareholders. So the point here is that a company can go for the buyback of the shares under the provisions of Section 68, either for the shares as well as from the other specified securities. What is subclause number 2? So it says subject to subclause number 2. What is the subclause number 2? Subclause number 2 speaks, no company shall purchase its own shares or other specified securities under subsection 1 unless authorized by articles of association. Kindly remember, if a company has no provision in AOA, right? If the company has no provision in AOA, it is not permitted to go for the buyback. A company cannot claim, since company law permits, that I can go for the buyback. The company law is very specific that every company has to adopt, right? Every company has to adopt under the articles of association stating that it can go for the buyback. Number 1, a buyback has to be authorized by articles of associations. Number 2, a special resolution has to be passed in a general meeting for the purposes of the buyback. That is number 2. And number 3, if the buyback is 10% or less than the total paid up capital and the free reserves of the companies. So they provide, the buyback is the less than 10%, you don't require to follow some of these provisions. So generally they provided a buyback has to be authorized by the articles and a special resolution has to be passed in the general meeting. Now, subclause number 3, such buyback has to be authorized by the board by means of resolution passed at its meetings. Again, the board of directors has to pass a resolution stating that it is authorized by the board of directors. Point number C, if the buyback is 25% or less of the aggregate capital and free reserves of the company, the provision has provided the how much the percentages. To put it in simple understanding, sir, what is this 10%? What is this 25%? Now let me make a simple analysis to understand for ourselves, right? Then we can have the very easy understanding. If the company has 100 shares, whether it can purchase 10 shares back or 25 shares, or can it purchase 50 shares back? For example, it is purchasing 10, we can say 10 into 90, 25 into 75, and 50 into 50%. I think we are getting my point. If the company is having 100 shares which are fully paid up, how many shares it can take it back? That's what they put it, 10%, 25% or the 55%. The buyback of the shares comes to the provision of 25 to 75%. This logic you can apply for if the company is having 10 lakhs shares, then 25% of 10 lakhs. If the company is having 1 lakh shares, 25% of 1 lakh is the 25,000. So if the company is having 10 lakhs, it again comes 2,50,000. So a particular percentage has to be maintained. The reason is that why the percentages are being given under the Companies Act. We will see one by one the provisions of company law. And point number D, the ratio of the aggregate of secured and unsecured debts owed by the company after buyback not more than the twice of the paid up capital and the free reserves. So this is a very important concept, because what happens in the general, let us take this small example, the balance sheet of the company. In the balance sheet of company, we have share liabilities side, right? On the liabilities side, then you have assets. On the liabilities side, you have the share capital. You are having the other one is reserves and surplus. Then you have the free reserves. If I am purchasing the shares of these shareholders, the money is coming from reserves and paid to the shareholders. I will repeat again. The money which is there in the reserves and surplus is taken out and will be paid to the shareholders, and the shareholders will be out from the board or out from the capital, out from the companies. So therefore, always the money which is here should be kept to a particular proportionate. The money which is in the reserves and surplus always is kept for the benefit of creditors, particularly secured creditors, right? You have a secured creditors in a company. So therefore, secured creditors will keep an eye on the reserves. If any one of you are reading the balance sheet of the company, don't always look about the assets of the company. Always read the balance sheet of the company. How much reserves and surplus is there? How much capital is there in the free reserves? Because the amount which is there in the free reserves, the amount which is there in the reserves and surplus is not meant for using of day-to-day management of the companies. Whenever there is a huge amount of reserves and surplus, always the people who looks at the balance sheet of the company, they identify and they designate these companies financially, right? This company is financially sound. It is also a good companies, right? If the company's reserves and surplus are good, the presumption is that this company is the financially sound. When the company is the financially sound, always there is a possibility that lot of outsiders, lot of the people who have the mindset, who wants to take over the company or who want to destroy the company, there is a possibility of hostile takeovers and sometimes also friendly takeovers. If the company is financially sound, if the company is financially good, that there is a possibility that anybody who belongs to the other managements, they try to acquire the shares. When this acquisition happens, then automatically the creditors who has the obligation by the company, that company has to repay to the creditors from the money of the reserves and surplus, they always have to keep the balance between debt and equity ratio. That means once the company go for a buyback, you should have the financially sound even after the buyback. The meaning thereby is that a company is not permitted to take the money of the reserves and surplus and give it to the shareholders. Later on, company can file insolvency, right? Company cannot go for the filing of insolvency petition after taking the money from the reserves and surplus money. So therefore, company law made it very clear. You can take some percentage of the capital from reserves and surplus. At the same time, you make the uniformity. You also keep the solvency of the companies. We will see that provision in the continuation. So a company which is going for a buyback, it has to make the debt and equity ratio that is 2:1. Now point number E. All the shares or other specified securities which are going to buyback are to be fully paid up. The buyback of the shares or other specified securities listed on any recognized stock exchange is in accordance with the SEBI regulations. This is what I am telling. Section 68 has to be read with SEBI buyback regulations, right? SEBI buyback regulations 2018. If anybody wants to give an advice, if anybody wants to provide legal opinion, or if anybody wants to advise the company on the manner and the procedure for the buyback, that they should inform to the company that this is what the process. So therefore, SEBI regulations comes that talks about and also informs about the procedure of the buyback. No one can say that I will only read the section 68 of the Companies Act, therefore I am the master of the buyback. Kindly remember, those who are reading the buyback, they should read as a mandatory requirement section 68 read with the buyback regulations of 2018. Now point number G. The buyback in respect of the shares or other specified securities other than those specified security clauses in F is in accordance with the such rules as may be prescribed, provided no offer of the buyback under this subsection shall be made within a period of 1 year from the date of preceding offer of the buyback, if any. So the procedure is that if the resolution is passed, say for example on November 4, 11, 2022, from here in a year, that means 2023, November 3. So within a year, they have to complete the process of buyback. Then the notice must be given when there is a buyback. The board of directors have to call for a meeting. In the board of directors meeting, when the statement was given or a notice was given, it shall contain the explanatory statement for the purpose of the buyback and also full and complete disclosure of all material facts and also the necessity for the buyback, why the company is going for the buyback, and it will also talks about class of the shares from whom they want to buy back, how much amount need to be invested from the buyback, limit and the time limit for completion of the buyback. As I told in one of my hypothetical example, like when it is identified the people from whom it is going to buy back, how much money it is taking from the free reserves or the reserves and surplus account, and the duration for the buyback need to be specified under the notice. And the duration, every buyback shall be completed within a period of 1 year from the date of passing of resolutions. The buyback under this subsection may be from existing shareholders or from the open market or by purchasing of securities issued to employees of the company pursuant to the stock option or sweat equity, where the company proposes to buy back its own specified securities under this section in pursuance of the special resolution under the clause. Actually, this is where you try to identify from whom to purchase. As I have given a small example, in the case of the X Limited is having the 500 members, having each one share. If the company wants to purchase 100 shares, how to identify 100 persons, right? How to identify 100 persons out of 500. This is where one of the big question comes in the corporate law. Because if everybody wants to submit, and how to identify these people, whether you follow from the open market or you go with the draw of lots or about the book building process, because what the methods are provided under the Companies Act and also under the buyback regulations to identify about the seller and by various mechanisms which are provided under the company law. Now subclass number 7, where the company buys its own shares, it shall extinguish and physically destroy the shares and securities so brought within 7 days from the completion of the buyback. Some of you may have a doubt, sir, now the shares on the demat, how to destroy these shares? It is very simple. If a company purchases the shares from the existing shareholders, it has to remove the names of shareholders, and the same number of shares, or the type of shares shall not be issued again. So the company law made very clear, it is not permitted again to issue the same number as well as the same type of the shares once it is being purchased back, because it creates another problem. Some of you have a doubt here, why it cannot be issued? Why it cannot be issued means, in the case of further issue, what will happen? The capital will come into the company, right? If the company issues the shareholder, now company becomes a seller. I will put it very example. If you have the company, you have the shareholders. In the buyback, what will happen? Shareholder becomes the seller, company becomes the buyer. If it goes on for reissue, then company becomes the seller and the shareholders becomes buyer. This is the routine process where company is the seller, where the individual investors are the buyers. In the case of the buyback only, shareholders are the seller and company is the buyer. So this process they don't want, because this process generally happens where the company raises the capital by issue of the shares. The buyback of the shares is a little bit contrary to the regular process. In the case where the company is the seller, investors are the buyer, the capital comes as inward to the company. Whereas in the case of the buyback, capital will go out from the money which is available in the reserves and surplus. So they try to understand about the concept of the buyback in the simple terms. Now the discharge of the stay warrant that you don't require maybe immediately. Now the manner has to be followed, and they have to make about the physical destruction of the shares. This is what we call about the physical destruction of the shares. And they also provide no further issue of same type of shares, right? No further issue of same type of shares. So that is being prohibited again under the Companies Law. Now, once the buyback is completed, right? Once the process of buyback is completed, a company has to file before the registrar and also before the SEBI, right? A company has to file before the registrar plus before the SEBI with regard to the particulars of the process, and also inform to the SEBI how the process has been completed, from how many people it has collected them shares, how much capital it has paid to them. So it is what we call about the post-issue or the post-offer proceedings. Once the company completes the process, once the company completes about the offer process, it has to inform to the SEBI as well as to the registrar about the procedural aspects. Funding for the buyback, as we have already discussed, we have to take it from the securities premium account or the free reserves. And conditions again provided under the Companies Act, authorized by the articles and other process. Debt and equity ratio has to be maintained. That is the 2:1. Debt and equity ratio should be permissible range. And buyback only happens with regard to the fully paid up securities and regulation prescribed for the listed companies. Rules made for private and non-listed companies by the central government. This is point number 8. Declaration of solvency and extinguishment of the securities. Further issue of the same kind of securities shall not issue within 6 months. So I am again coming to the point number wise to make you easily understand. Number 1, buyback need to be authorized by articles. Board has to pass the resolution and authorization of the special resolution. Special resolution to be passed by the postal ballot also. And quantum of buyback should be, limit is there, 25% to 75% and also 10% to the 90%. Buyback of equity shares in any financial year shall not exceed more than 25%. So that also comes as the rider about the 25%. Then the debt and equity ratio, this we have already discussed, 2:1. Then fully paid up shares only you can go for the buyback. Regulations prescribed for the listed companies. Rules made for the private and non-listed public companies. Declaration of solvency and extinguishment of the securities. Further issue of same kind of securities shall not issue with the same. And the listing agreement and conditions. 7 days notice to stock exchange. SE stand for the stock exchange. Board resolutions. Public announcement, the process when you go for the stock market, the procedure of the public announcement as well as to the 30 to 40 days and 7 days to the stock exchange after the process is done. Effect of the buyback on whether investments by FIAs, that is the foreign institutional investment, investments in the Indian joint ventures, tax implications, income tax and capital gains tax, because any transactions which happens in the capital markets for the acquisitions and the procurement of the shares, it attracts about the tax liabilities. And there are some of the methods are provided, the manner in which company can buy back its shares from the existing shareholders through open market, book building process, through the stock market, as well as from the odd lot holders. And the another important document that everyone has to keep handy, SEBI buyback regulations 2018. So in the brief explanation, I try to explain the purpose and need of the buyback, what is there under the section 68, which is the substantive clause, right, which is the substantive clause followed by procedural clause, procedural aspects. So here I pause my lectures. Kindly listen carefully. If any one of you have any concepts, clarifications, as well as the doubts, you can write in the chat box. Then I will try to clarify those doubts in the next lectures. So thank you for patiently listening. Take care and bye.